Good morning, good afternoon, good evening. My name is Joey Barnett. I'm a partner at WR Immigration. Today, we have Charlie Oppenheim, former Chief of Department of State Visa Office Controls, with us. He is here to help explain what is going on in the EB-5 world, what has happened this month with the new news from the Department of State, and what we can expect for the upcoming months. Charlie, great to see you.
Good to see you all. Happy to be with everybody.
Thank you so much for being here. We always appreciate your unique insights because you worked at the Department of State for so long, and this stuff is just so confusing, even to immigration attorneys who do this on a daily basis. These estimates for visa use and how it works with the Department of State and the visa office and USCIS to make sure that all available visas are issued in a fiscal year. That's a very complicated process, right? A lot of different moving pieces. And I think your insights here will help hopefully provide some clarity to others. We're also going to be talking about just some general EB-5 processing questions that I get asked frequently. And thank you so much for listening. This presentation does not constitute legal advice. I have to say that. I'm a lawyer. It's just for information purposes. But if you want to speak with an attorney, please contact our firm, visalaw@wolfsdorf.com. We'll also give you some QR codes at the end of the presentation you can look at with your phone and reach out to us if you want to contact. So thank you so very much for joining us. Again, I am a partner at WR Immigration. I am based out of our Los Angeles office. We are a very well recognized immigration law firm, and we would be happy to help you, your family, your employees, anybody with their immigration journey. Okay, so here's the overview. I kind of went through it. Let's get right into the meat of it. All right, this here that you're looking at is the final action date, Chart A, of September 2024, which is the last month of fiscal year 2024. The fiscal year starts on October 1st, and that is when a whole new set of visas are allocated. Right now, we are at the end of a fiscal year, and we're starting to see that there could be some unavailability, and we're going to be talking about that. But first, let me ask you, Charlie, were there any changes in Chart A final action date from August to September?
No, these final action dates for unreserved China and India have remained in effect for probably 6 months or so.
And that's expected, right?
Yeah, that was pretty much expected because of the amount of demand on a worldwide basis. So State Department has been holding the dates.
And what is your thoughts about any changes in these final action dates when the new fiscal year starts on October 1st?
I think that it is very likely that they will hold these dates for the month of October because, as we will talk about, the limits have already been reached for fiscal 2024, meaning that they may need to be processing some cases in October that would normally have been processed at the end of the year. So they may be somewhat hesitant to move any dates for the month of October.
And is that somewhat of a repeat of what happened in Vietnam at the beginning of this fiscal year when they had all of those visas that were issued in the first couple of months of the fiscal year this year?
Yes, it is. And it's not unusual. Typically, if a category has run out of numbers or a date has retrogressed in any employment category or the family at the end of one fiscal year, often those dates would be held for October so that they could process those cases that have been held up, which would require more numbers to be used in October than normal. But I think that we may see some dates moving starting effective in November. It is possible, though, that if either of these two dates changed, it is more likely that the India date would be advanced than the China.
And can you just give us your rationale for that?
I think that is that the India date has a less demand than the China with early priority dates. Hopefully, much of the India demand with early dates would have been processed this fiscal year, allowing that date to begin moving forward more quickly during fiscal 2025.
Okay, great. So we've been talking about the unreserved visa category. Now let's switch over for a moment to the set-aside visa categories that were created after Congress enacted the EB-5 Reform and Integrity Act, which has sort of reinvigorated the EB-5 industry and brought in billions of dollars of investment over the past 2.5 years. We've talked about this in the past, but I just want to say, what does that C mean?
The C represents that numbers are currently available for all applicants who have an approved petition. There are enough numbers to allow immediate action on their cases, and that is for the month of September. It is important that the final action dates that apply in the month the case's final action is occurring are the ones that govern processing at that time, not what they were when the applicant filed.
Right. And that's a really, really important point that I want people to understand. There is a benefit for these set aside categories that are current right now, at least for those in the United States, because you can file an adjustment of status. You can file for the interim benefits of an employment authorization document and advance parole. But what really matters is what the final action date is at the time that your I-526E is approved. If your priority date is after the final action date, then USCIS will not be able to approve your adjustment of status, and the Department of State will not be able to issue your visa. Now, this is obviously a big reason why EB-5 kind of went away for a while, as these backlogs that are formed. And I'm telling all of my Indian national prospective clients and all of my Chinese national prospective clients that there likely will be, in fact, there will be a backlog at the time that your I-526 gets approved. It's something that I want people to have an expectation of because it's been current, but the Department of State has not yet issued a single reserved or set aside visa number. And we know that there are over 5,000 cases that have been filed by EB-5 investors since the RIA was enacted. And it's based on priority date. Your priority date is based on when you invest and file your I-526. So all of those cases and all of their derivative beneficiaries are going to get a visa quicker than somebody who files tomorrow in the same visa category. And so I just want people to really have that understanding. There is a benefit because you can remain in the United States if there is a layoff and you can't find a job after that 60-day grace period. Or, maybe you're graduating or you've graduated and your OPT is up. You have that adjustment of status. You can remain in the United States because it's current. So there is a benefit to it. I would say, though, that the benefit is greater to those who are in the United States than those who are outside of the United States. All right, so this is chart A, and then now we're going to move to chart B. Chart B, well, Charlie, can you just tell us sort of the thought behind chart B?
Sure.
In general, just the theory?
Yeah, chart B is used to allow applicants to begin submitting any required documentation if they're processing overseas and to potentially file for adjustment of status for processing in the U.S. The reason those application filing dates are imposed is to start generating demand that will be needed later in the fiscal year and allow the annual limits to be reached. And we let the applicants start doing that information early, so when their priority date is reached, their case hopefully will be available for immediate action in the month when it becomes available, and not just start submitting the documentation in that month.
Right. It's sort of like you're pre-charging something before you use it. You're getting it ready so that when a final action date is actually current for somebody, they can take that final action. Am I right?
Yeah, and it allows for less by imposing these application filing dates and allowing applicants to file early and become documentarily qualified and be processed by the USCIS as well. It lessens the likelihood that there will be volatility in the movement of the dates, because the State Department, when they're making the determination of the movement, will have an idea of how much demand is within the dates they establish, and so which is a very useful thing to know.
And for those in the United States who can use Chart B with the adjustment of status filing when USCIS allows it, you're allowed to freeze your child's age as well. So there's that added benefit. We're hopeful that the Department of State changes their interpretation and allows for that as well. But that is something that is also a benefit there.
Right. And so yes, and it's very important that people, when USCIS is allowing the Chart B application filing dates to be used, it's very important that any applicant who is eligible to do so files as quickly as possible, because often USCIS will only allow those dates to be used through January as much as March. So timely action is extremely important.
And that's because, correct me if I'm wrong, when you get to the second half and later part of the fiscal year, there's just less visa supply. And so they don't need to generate that demand in order to use all of the available visas for the year. Is that right?
Yes, it is.
All right, great. Anything else on the visa bulletin for September that you are interested in? Oh, well, actually, I have a question for you. What are your thoughts for fiscal year 2025 for the set-aside categories?
At this point, I think that all of the reserved categories will be current through at least May of 2025, if not for the entire fiscal year. A lot depends on how fast both the State Department and USCIS ramp up their processing of the reserved cases, and any type of date will not be required until the actual number use and demand exceeds the annual limit. So again, I think they will be current through at least May, if not the entire fiscal year. But I think it is important to remember that effective for fiscal year 2026, final action dates will be imposed, possibly as early as October of 2025, which is the first month of fiscal 2026.
Got it. Okay, that's very helpful. All right, so the process for EB-5 petitions. This is something that I get asked a lot about, and I want to try to explain it so that people can understand how these cases get adjudicated. And this picture that you're looking at here is actually from USCIS's website. And the way that it works is that a regional center files a 956F for a specific project. Once that has been filed, investors can file their individual I-526Es and invest in the company. USCIS will need to approve the I-956F before it approves the I-526Es associated with that project. The thought being, well, why am I going to spend time on source of funds of an investor if the project that they've invested in doesn't comply with EB-5? They're not going to waste their time. So it's a way to make things a little bit more efficient. So for folks who are filing an I-526E for a project that doesn't have a 956F approval, you may be waiting a little bit longer depending on when the 956F was submitted. And there is a risk, although the likely, how high it is depends on the project that you're looking at, that the 956F gets denied, and then your I-526E would get denied. So I like projects with 956F approvals because it shows that USCIS has reviewed the documents, the business plan, the economic analysis is reasonable, the offering documents, the PPM, the operating agreement, all of that complies with immigration and securities laws. And, it gives you a sense of peace that your I-526 is going to get approved. And when you file that I-526 for a set-aside visa category that's current right now, you're also able to file the adjustment of status. That's what we were talking about in the last slide. And along with the adjustment of status, you're able to file for the EAD so that you have unrestricted work access, as well as advanced parole, which allows you to travel internationally during the time in which your adjustment is pending. Now, there's this concept of priority processing that USCIS has implemented in the past couple years related to rural processing. That, from what I have seen, really only impacts 956F adjudications and I-526E adjudications. It does not impact how quickly you're going to be getting an EAD or an advanced parole. Okay, the priority processing, you're not going to get a faster EAD because you invested in a rural project. That's not how it works. USCIS splits up the applications, the adjustment goes, and the EAD and the advanced parole go one place, the I-526 goes another place. And once the 956F is approved, they have the ability to approve your I-526. Once your I-526 is approved, if a visa is available, they have the ability to approve your adjustment of status. And at that point, you would adjust from your non-immigrant visa status or your pending adjustment status to a conditional green card. And so, that 956F is important. It's something that I tell people to look for when they're looking at projects. But there's also a lot of good projects out there that have I-956Fs pending, and we're just waiting for USCIS to approve them. So, you kind of have to, and some of the projects that have the approvals may be already subscribed. They may not be taking any more investors at that point. So I just wanted to touch base on this because it's something I speak to prospective clients a lot about, and I thought it would be helpful. But let's move to the next, and I guess the bigger news in EB-5 that came out not last Friday, but the Friday before. And they had announced that the unreserved category for EB-5 had been reached. And I think this was pretty surprising to everybody in the EB-5 industry. What are your thoughts, Charlie?
It is a little bit surprising that it happened earlier. I would have expected it more likely sometime during the month of September. It is possible that the amount of adjustments being processed by USCIS was greater than anticipated, and or that the amount of numbers being used during the month of July was higher than they had originally expected when they set the August dates.
So let me give some numbers here. Because of the carryover of the fiscal year 2022 numbers, and this is at the bottom of that second paragraph, there are a total of 14,169 unreserved EB-5 visa numbers this year. As of the end of June, the Department of State had indicated that 8,862 of them had already been issued. That means that there's over 5,300 unreserved visa numbers that must have been used through an adjustment of status, the month of July, or the first half of August. Is that accurate, Charlie?
Somewhat. It is important to remember that when the State Department made the determination of both the August and September final action dates, at that time, they would have allocated numbers for potential use during the month of August and or September, and allocated numbers to overseas posts for any applicants who were being scheduled. So despite this announcement that the limit had been reached, any applicant who had been scheduled for an interview by the National Visa Center for interview at an overseas post during the month of August or September, a number should, in theory, be at the post, quote, reserved for that applicant's use if they are found eligible for visa issuance at the time of final interview. So again, despite this notice, you could have somebody that's interviewed at a post EB-5 processing overseas that could actually have an EB-5 visa issued today, and somebody that's scheduled for interview during the month of September, a number in theory should be available for them at the post when they show up for their interview, unless that interview were canceled. What this notice means is that any adjustment of status application, if the case is finalized today, the Immigration Service would not receive authorization when they submitted the request to the visa office. But the beauty of that is that request from USCIS would be held by the State Department and potentially authorized effective October 1st, allowing USCIS to process the case at that time.
So you're not expecting any adjustment of status approvals for the EB-5 unreserved category for the next month?
No, there should be none in the remainder of August or at all in September. The next adjustment of status for unreserved visas would be effective October 1st.
Got it. And, our firm and other firms have received some notices from the U.S. consulate in Guangzhou saying that, hey, your interview's been canceled because there's no longer a visa available. Despite that, I would continue to go to your interview and to act as if a visa number is available until you get that notice. Some people are getting it in the mail ahead of time. Some people are getting it when they get to the interview. Now, I had a client last week after this notice was issued, not in China, it was in the U.S. consulate in Johannesburg in South Africa, and they took their passports and they said the case was approved. Now, we haven't yet gotten the immigrant visa back yet that are in their passports, but it is obviously good news that they took them. I'm hopeful that we get it next week, or maybe we'll have to wait until October 1st. It's a little bit up in the air. Charlie, anything else you wanted to say about that?
No, and that speaks to the point where Johannesburg would have been allocated an August number for that applicant. So therefore, when they showed up for their interview, despite this notice that the limit had been reached, they had a number available for that applicant and could issue the visa. The difference would be if that had been a comeback case, had that applicant been refused, say in July or June, and was just returning, the post may not have a visa number available because those were not first-time applicants. So the first-time initial scheduled applicants for August and or September, a number should have been reserved at post for use by that applicant, whereas an applicant coming back to overcome a refusal from an earlier month is unlikely to have a visa available for them.
So when you were working in the visa office, is this time of year usually crazier than other times because you're trying to use all of those numbers and making sure that, the consulates have what they need? I mean, how does the Department of State do that?
It is it's a little bit stressful at this time of the year because it's important to remember that the State Department made the determination of the August dates in early July. So they were having to make estimates of how many numbers would be used during the month of July and how many would be returned. And those return numbers would go into the pool available for use during August and September. So then in early August, they made the determination of the September dates and returns. So if they had been estimating that, say, 10% of the EB-5 unreserved numbers that were allocated for July use would be returned unused, and they only got 5% back, then they would have a shortfall. They would have, been giving out more numbers. And that is the type of thing that is potentially caused this category to go unavailable at this time.
Got it. And so are you expecting, just to go back to our chart A, and this is the question I was going to ask you before, is are you expecting when they issue like the true September visa bulletin, or I guess, are you expecting them to modify it to say it's unavailable?
No. Typically, once a visa bulletin is announced, they will not update it. They may, as they've done here, make an announcement that no additional numbers would be available. And again, when they're saying no additional numbers, they're talking about cases that are being processed in the U.S. by USCIS, where they only request visa authorization once 100% of the required processing has been completed, and they're ready to complete the adjustment once they get the authorization. It also affects comeback cases. Again, cases that were refused in an earlier month, those applicants, although they had a number, quote, reserved in that earlier month, if they didn't use it, it would have been returned and put into the pool available for future use.
Thank you. That was really helpful. And I like the way that you explained it. It definitely made it clear for me. And to be clear, this announcement doesn't really impact EB-5 investors who are signing up today and investing today. I mean, it's not going to impact their I-526. I guess in theory, well, no, it shouldn't really impact anything because the Department of State isn't issuing the reserve visas at this point, right? I mean, that's the big issue.
Correct. This announcement only is the unreserved applicants. It has nothing to do with the new reserved categories that were established under the Reform Act. So again, this is only for the pre-Reform Act applicants who had filed.
Or for those maybe who aren't in the set aside post RIA, although there's probably few of those, not too many of those. Okay. Thank you, Charlie. That was really good. Is there any other final comment you want to say about this unreserved limit being reached that may be helpful to understand how the visa office really puts this all together?
On the surface, it looks bad because everybody's saying, oh, there's no more numbers for the remainder of the fiscal year. But actually, this is in a sense, a good thing because it means 100% of the numbers available for fiscal 2025 have been used, whether they're already used now or the limit would have only been reached at the end of the September. So nobody has been, quote, harmed by this. And it's also a good thing because the fact that they were fully able to utilize all of the numbers should have allowed them under this extremely high limit to really eat into any backlog of pending cases, which is a benefit for processing in fiscal 2025 and beyond. So this is, in a sense, a good thing that this has happened.
Right. And this means then that there are no unused, unreserved visa numbers that would fall up for use by EB-1 applicants as well, right? All of the EB-5 visas that were allocated for this year, minus the reserved ones, are being used. And that's the second year in a row that all of the unreserved visa numbers have been used fully. So that is a good thing. And I guess I'll also say is that when I'm looking at these monthly issuances by the Department of State, it has gone up steadily by around 400 since April. And in April there was 880. In May it was around 1,200. And in June there was around 1,700. So maybe we'll see in the month of July that they were able to do another 3,000. And you add in the adjustment of status applications at USCIS, and that's where you sort of somehow reach that 5,300 that we don't know have been used at this point.
Right. And one thing that we used to see often is people that were eligible for interview earlier in the year sometimes would reschedule their interview for example, for the summer months because they wanted to do so when their children would be out of school or it may be more convenient for them. So that is sometimes why you would see lower number use early in the year and it pick up at the end. The risk is if people reschedule their original interview, they risk, in this case, numbers not being available later in the fiscal year. So it's always best for people to hold their original interview date unless it's an extreme hardship.
Excellent. Well, thank you so much, Charlie, for coming in and sharing your incredible insight. I don't think there's anybody else in the world who can really explain this stuff. Well, at least a non-government official who can explain the stuff. So thank you so much. And thank you all for listening. And we will see you again next month.